Let's pick up where the last video left off. We were talking about serving the contempt documents to the other person. If you can't get the paperwork served, the courts will generally reissue the paperwork and give you a second chance to serve, as long as you show up on the date stated on the citation. If you can prove service and the other side fails to appear, then you can ask the court to issue a warrant to arrest the other party. For the purpose of this video, it's assumed that everyone has appeared at the same time and place for trial. If you haven't already watched the first two videos in this series, you may want to go back and do that now. This video focuses on remedial contempt cases. If you've watched the first two videos, you mostly likely understand that the judge has to be convinced that the defending party in a contempt case has present ability to obey the court order before any kind of penalty can be imposed by the court. Remedial contempt is only available to remedy or fix a situation. A judge cannot punish a defending party in a contempt case when imposing a remedial contempt sanction. A sanction is a penalty for disobeying a law or a rule. Let's explore these two ideas further. Depending on the situation, it can be easy to provide convincing evidence to the court of the other party's ability to obey the court order. For example, if the order is about parenting time for a young child who is in physical custody of a parent who refuses visitation, then the party seeking contempt may only have to provide evidence to the court to prove missed parenting time. When presenting ability to pay money is the issue, providing there is ability to obey the court order can be more difficult. Perhaps recent photos of the other party working on a construction crew are available as evidence, or proof that the other party is driving an expensive car. As long as the person filing the contempt case has evidence to make the judge believe that the other person does have the present ability to comply with the court order, the case should be allowed to go forward. Once this type of evidence is offered, the court will shift the burden of proof to the party defending the contempt request. If you are defending yourself against remedial contempt case, this is perhaps the most important thing you need to know. You may be faced with proving that you cannot comply with the order at this time. In this situation, you need to go to court prepared to offer your proof. Parenting time issues may hinge on whether the child is beyond the control of the parent. This is especially true for older children. For financial issues, a recent layoff or health diagnosis may convince the judge that the order cannot be obeyed at the present time. Disclosure of a home foreclosure, wage garnishments, or an empty bank account may also be convincing, so long as the judge does not suspect fraud. Expect the court to listen to both sides before making a decision. Suppose the court announces there is a valid court order that the defending party knew about, has disobeyed the order, and has present ability to comply with the order. What's next? Imagine the court asks the person filing the case what they want, and they say, impose 6 months of jail time, fine the other party $1,000, and terminate the other party's parental rights. Can the judge do any of those things? The answer is no. Imposing a fixed jail sentence and imposing a fine are punishments and are not remedies designed to ensure that the court order is obeyed. In a family case, ending the other party's parental rights is not possible in the proceeding. Remedial contempt can only enforce an existing order, not change the agreement between the parties regarding parental rights. Drafting and deciding on a remedy can be the hardest part of a remedial contempt case. Examples: if there is $50,000 of unpaid child support and the other party has $50,000 in cash, the court might say, go to jail until the $50,000 has been paid. Setting up a wage assignment that was originally ordered but not activated might help in a case involving periodic payments. Small amounts of making up parenting time may be ordered, but if the change would radically alter parenting arrangements for a child, this may not be allowed. This fix might be considered beyond the scope of a remedy and into the realm of changing the underlying court order. There is nothing more dispiriting for the person who filed a contempt case than having a judge agree that there has been contempt, but also decided there is no appropriate remedy. A judge may decide not to award your attorney's fees for or impose a remedy for a single violation of the court order. On the other hand, a steady pattern of disobedience coupled with the ability to comply may persuade a judge to require posting a bond or imposing suspended jail time designed to force the other party to comply with the court order. Number 8 on JDF Form 1816 provides a space for you to write down what you want as a remedy. Read this carefully. If you win, you can ask that the other party pay any attorney's fees. As a defending party, the appearance of a lawyer for the party seeking contempt could be expensive for you if you lose. Jail time and fines are an option in a remedial contempt, but only to force the other party to follow the court order. Fixed-term jail sentences for a period of time are not available in remedial contempt. A fine of a specific number of dollars per day might be imposed on the defending party until the person complies, but not a single large sum imposed as his punishment. Finally, the court expects the requested remedy to be spelled out in JDF 1816, both out of fairness to the defending party and also so that the court can see at a glance whether the party seeking contempt is asking for something the court can do. The case may be dismissed if no practical remedy is available. This is why you must be very specific when filling out the other section in number 8 on JDF 1816. If you have made it this far, now would be a good time to read Colorado Rule of Civil Procedure Rule 107, especially sections 6D2. It should begin to make sense.